pull towards the right side corner of the screen. ಅಲ್ಲಿ ನೀವು
Small
ಹೋವರ್ ಮಾಡಿದ್ರೆ
thumbnail.
ಥಂಬ್ನೇಲ್ ತರ ಇರುತ್ತೆ. ಇಫ್ ಯು ಹೋವರ್ ಓವರ್ ಯುವರ್ face.
So, participants, hi. Greetings of the day on behalf of the team. So I welcome you all. So, as you know, you have listened to the 6 weeks of lectures now, and we had one more live session back at the end of the 2 weeks. This second live session is a special one. As you know, on this month, on 12th October, the RTI Act has completed 15 years. So in this live session, we are going to discuss what were the accomplishments that the RTI Act has made in these 15 years, and what are major concerns that the implementation of the Act has to face in these 15 years, and also what can the way as we go forward. So I will share my presentation now, and I hope that this late you will not be having much work to do. I hope the IPL matches are there, so I hope that you will not be distracted, and you will have us time. So as you know, guys, the Ashera is just been concluded, and next festival is Pauli. So in that context, let me make this statement that there is I know that some small bombs can cause a very huge explosions. This RTI Act is one of such bombs. It is very simple and only few sections are there, but the impact of this legislation that has been monumentous. It has changed the governance functioning, the designing of the governance, how the governance structure should function with more transparency and with more means accountability. So in this regard, I will share my screen with the 15 years of Right to Information Act. So I hope everyone can see the screen. So the Right to Information Act was an outcome of a vibrant grassroots movement. So as you have heard and you have learned in these 6 weeks, how the MKSS movement and the movements that were originated in the grassroots to fix the issues faced by the common man in his day-to-day life, how this led to the Right to Information Act. The act was passed by the Parliament on 12th May 2005, and the act came into force on 12th October 2005. That means on this 12th October 2020, the act has completed its 15 years of enforcement. What we have learned so far in this 6 weeks is how the act was designed, what were the sections of the act, and how the cases have been dealt with under the act. But in in this live session, we are going to do some statistical view of how the Right to Information Act has been implemented. These statistics were compiled by a sangathan called the Hatrak Nagrik Sangathan, who has been very proactive in this field. And
Tark
these,
Nagrik Sangathan. Yes.
yes, sir. Hatrak
In
Nagrik
short, sometimes it is known as SNS.
SNS, sir. Yes, sir.
SMS, but now this is SNS.
SMS, sir. Yes, sir. So these statistic that came around a month back shows some pictures, portrays a picture of the implementation of the Right to Information Act. So as you have learned, the Act mandates timely response to a request for information from a public authority. The Act is a tool in the hands of the common man to seek information regarding his or her problems. Now, I have laid down some statistics in front of you. The questions that were sought from the authorities, out of those, 5% were linked with taxation matters, how much tax is charged and all that. 6% was the business information, but 29% and 39% of the information that was sought was from the panchayats and municipal departments, that show that a common man is seeking his information, the issue that he faces in his day-to-day life. So he has sought the information regarding those problems. Moving ahead, let's discuss the accomplishments of the Act, sir.
It's very clear from Vikas's first slide and first presentation that the kind of information that citizens ask are close to them, to their needs and to their grievances. For example, taxation. Why are citizens seeking so much of information on taxation? Obviously, because most of us don't like paying tax. I'm not sure whether we like paying tax, and I'm sure we know that currently I may be interested in knowing about Mr. Vijay Mallya. Okay, this guy seemed to have defrauded banks. I must be probably interested in knowing about Nirav Modi. So I also, like Ram Jethmalani, the former senior counsel in the Supreme Court and a very famous criminal lawyer who is no more with us, he was also interested to know about who are the black money defaulters. So in Swiss bank account, that people are unfortunately opening accounts so that they can evade tax in India. So this is quite a common information that people ask. And for example, municipalities, I'm a citizen, I'm seeking civic amenities from the municipal corporation, right? So these are close agencies or close government departments that are citizen centric. And naturally, there are a lot of right to information applications that are filed to these organizations. It's quite obvious, right? So RTI is a tool in the hands of citizens to demand accountability from a government, not that one that always sits in Delhi and is far away from them, but a government that is very near and that probably has a duty of providing basic civic amenities to its citizens. So I think that is very eminent from the statistics that Vikas has just presented before you. Over to you, Vikas, for the second slide.
Thank you, sir. So the accomplishments of the RTI Act. So as I've said, the Act has redesigned and strengthened the working of the governance structure, the municipalities, the panchayats. These functionaries are very hard to deal with before the commencement of of the RTI Act. But now it has redesigned them. The Act has redesigned them in a way that now they can be more accountable, and they can function in a transparent way. In the 15 years of the Act, nearly 33 million RTI Acts were filed. So RTI applications were filed, and nearly 60 lakhs applications are filed each year. And a large proportion of these applications are filed by the poorest and the most marginalized. And out of these 33 million applications, only 9% have gone to the commissions for the appeal, meaning that 90% of the applications were satisfied with the responses that they've gotten. This is the most important accomplishment of the Act. The Act has brought, before 2005, we can say there was a status of non-accountability. The Shield Secrets Act and all those acts, that special acts were there that stopped the government functionaries to disclose the information. But after the RTI Act, the shift has been there from complete accountability to increasing accountability. The Act has been a tool to expose corruption also. And for you guys, I have shared 2 links. These are which I found. I will share them with you. These are the success stories of the RTI Act that we can watch and learn from them. I will just show you this now. I'm sure you can see them out. Just 2 minutes of time, and just listen to them.
और सरपंच उन्होंने ये पंचायतों के काम किए के बाद में ट्रैक्टर लिया, और ट्रैक्टर लेने के बाद में फिर मैंने ये पंचायतों के काम किए। मैं काफ़ी काम करता रहा पंचायत समिति में, ग्राम पंचायत में जो भी काम आता था मेरे को देते थे। जब सचिव और सरपंच उन्होंने कहा भी आपका पेमेंट मिल जाएगा, तो करीबन उन्होंने 16-17 हज़ार रुपये बाकी रख दिया, और उसके बाद में साफ मना कर दिया कि अभी आपके पैसे नहीं। तो मैं काफ़ी संघर्ष करता रहा, लड़ता रहा। सरपंच साहब से पूछा, मैंने कहा सरपंच साहब पैसे चाहिए, तो 3 साल तक मैं लड़ता रहा। उसके बाद में मैं कलेक्ट।
And then he filed an RTI asking about the records of people who have worked for them.
वीडियो साहब को जैसे ही मैंने एप्लीकेशन दी, एकदम वीडियो साहब बोला ये रिकॉर्ड के लिए आप ऐसा मत करो, और आपके 17,000 है, उसके आप 20,000 1 घंटे के अंदर दे देता हूँ, लेकिन ये कार्रवाई मत करो। फिर मैंने कहा भाई साहब मुझे पैसे नहीं चाहिए, मुझे रिकॉर्ड चाहिए। तो वीडियो साहब फिर इधर से भागा दौड़ी कर आके बैंक में से जा करके नेट केस पैसे ला करके मेरे को देने लगा। बोला कि सिंह आप पैसे ले लो, और हाथ जोड़ता हूँ, आप पैसे मत, रिकॉर्ड मत मांगो। मैंने कहा मुझे रिकॉर्ड ही चाहिए, पैसे नहीं चाहिए। फिर मेरे रिश्तेदारों को बुलाया, बोला ऐसे नहीं मानेगा ये, बोला रिक्वेस्ट करके इसको मना दो, कैसे कैसे ये रिकॉर्ड नहीं मांगे और पैसे दे देंगे हम। फिर उन्होंने बोला कि गाँव को इकट्ठा करो, इसको जात से अलग, न्याज से अलग कर दो। फिर उन्होंने गाँव को इकट्ठा किया, बोला केसर सिंह आपको जाति से अलग कर देंगे और समाज से अलग कर देंगे, लेकिन आप पैसे ले लो और रिकॉर्ड नहीं मांगना। तो फिर उन्होंने एक मीटिंग और रखी, 12 गांव इकट्ठे किए, 12 गांव इकट्ठे किए। बोला केसर सिंह आप 50,000 रुपये ले लो। मैंने कहा मुझे 50,000 भी नहीं चाहिए, मुझे जो मेहनत की है उसके पैसे चाहिए। मैं मांगा था, 2 साल तक लड़ता रहा, जब तक आप लोग सारे कहाँ गए, सबके सामने गया, मैंने कहा मेरे पैसे मांग रहा हूँ, दिला दो दिला दो। और अभी सब इकट्ठे होकर के आप बोल रहे हो कि इसके बच्चे मर जाएंगे, वो मर जाएंगे, रिकॉर्ड मत मांगो। हमने पूरा रिकॉर्ड का विवरण लिया, उसमें मरे हुए के नाम, हाजिरी और उसमें मतलब मैंने जिन्होंने काम ही नहीं किया, वो अहमदाबाद में नौकरी करते थे, उनके उसमें हाजिरी है। फिर मेरा पेमेंट क्या हुआ कि उन्होंने फिर घर ला करके दिया।
So, guys, these are two beautiful links that shows the success stories that are linked with the Right to Information Act and the impact the Right to Information Act has made in the day-to-day functioning of the conscious dismiss. Can anyone hear my screen?
No, Vikas.
Okay, I will
Try
just,
again.
yeah. So now,
Yeah,
Yes.
now I can see.
okay.
Yeah, it is visible.
Okay. So these links that I will share with you to on the PTL website. Do watch these links, and you will learn how the Right to Information Act has made through these documentaries an impact on the lives of the common man. Moving forward, the challenges that are faced by the Right to Information Act.
Just
One,
one second, Vikas.
yes, sir.
If you can go back to your slide.
Yes, sir.
See, I know what's interesting over here is looking at RTI as a tool for exposing corruption. Now, we all know that corruption in India is a major issue and a problem. And there are various regulations in relation to corruption. We know that very often than not, any issue of corruption is handled by agencies like the CBI, the Enforcement Directorate, and so on and so forth. We have legislations like the Indian Penal Code, the Prevention of Corruption Act. We have Lokpal in certain states. We have Lokayukt. And RTI is, RTI cannot deal with corruption directly, but it is definitely some kind of a check on the same. Now, what is interesting is that if we look at some of the scams that have happened in India, one scam that I would request you to read, because it should not be easily forgotten, is this Adarsh Housing Society scam. It's an interesting story on how probably RTI does result in exposing a major scam where a housing apartment was done for the widows of the armed forces, but was unfortunately encroached or grabbed by politicians. And the RTI was probably the first tool to bring this scam to the national forefront, right? So I think it's important to look at how RTI is used, and you know that it is used by citizens. We have activists who have used this law, who have been probably, I would say, as the watchdog of government functioning and holding government accountable. Now, you should also note that when I say 90% of the applicants were satisfied with the government response, that is, a statistics that is merely, subjective to the research that was done. Now, there is nothing like a satisfaction per se, but it's like, the government was asked for certain information, that information was provided to the citizen. Now, how does a citizen use that information to bring in accountability is a different, ball game altogether, right? So, 15 years of Right to Information Act, and we know that it has been a very, very volatile 15 years, because a lot of applications have been filed, and the government has been able to respond also. So I think it is satisfactory in that sense, that the RTI Act seems to be quite well implemented, at least in reality and on ground. Yes. Yes.
Yes. Moving to the difficulties that the Right to Information Act is now facing. One of the biggest difficulty is the vacancies in the key posts. Because if the head of the organization, head of the information commission is not there, is not being appointed, then how will the organization function? So in this regard, we can see that 9 out of 29 information commissions have no AIC. These states are UP, Rajasthan, Goa, Manipur, Telangana, Jharkhand, and Nagaland. They have no head of the information commission. 1/4 of the information commission posts are lying just vacant, and two information commissions of Jharkhand and Tripura are completely defunct. There is no post over there, and just they are not even functioning. And due to these vacancies and some defects also, there is a dependency of appeals before the information commissions. In 15 years, over 2.25 lakhs of RTI second appeals are pending before the information commissions.
When I mean second appeal, you will all notice that it is the appeal before the Information Commission. First appeal is supposed to be within the organization of the public authority. So second appeal here means the pendency is before Information Commissions, either state or center, as the case may be.
Yes, sir. As you know, guys, the Information Commission is statutory mandated to dispose of an appeal within 45 days. But the statistics shows that 9 commissions would take more than a year to dispose of an appeal. Some information commission takes more than a year. For example, the State Information Commission of Odisha takes on an average 7 years and 8 months to dispose of an application. The application that should have been disposed in 45 days is lying for over 7 years. Penalty that was mandated under the Act is being imposed in just 2.2% of the cases. The most important challenge that the RTI has fixed is the Amendment Act of 2019 that has completely diluted the law, because the post of the Information Commission that was supposed to be held for a fixed term has now been made as be prescribed by the central government.
It has been brought down from 5 years to 3 years. It
Yes,
still
sir.
a fixed tenure.
But
So
still,
this
sir, it
slide,
has been,
friends, is
yes, sir.
so this slide is, please note, are statistics that have been collated from the SNS report that marked the 15 years of celebration of the right to information law. So you will notice that this is the observation that comes forward. And the observations are pretty amazing for us to look into or take into consideration, because October is the month when the RTI was enacted, and it's been 15 years. So this is October 2020, completing those 15 years. So what did SNS as an organization find out? They found out very clearly that information commissions are unfortunately not patronized by government, which means that they are not adequately staffed, right? So the first point that you will notice is that Vikas says that many of the information commissions don't even exist or don't even function, especially in 2 states. I'm not so much concerned about Tripura, but I will be definitely concerned about Jharkhand, considering that it is a naturally resource rich state. And it may be backward, but definitely doesn't mean that it should not have a working information commission. But that's surprising, considering the fact that I think it is in these states that activists must force the government to have information commissions function with adequate commissioners and adequate staff so that the commissions can actually hold public information officers and public authorities accountable for the implementation of the right to information law. What is interesting from the statistics that is presented in this slide and by this organization called SNS is that many information commissions do not have chief information commissioner. Now, you will notice that, okay, so don't be surprised, the Central Information Commission does not have a chief right now.
Yes,
The last chief retired in August 2020. It's COVID-19 pandemic. Probably there is no appointment yet. But I think it is headless, as we would want to call it. Many other information commissioners of the state do not have a chief. They have information commissioners, but they do not have a chief information commissioner. Now, why should the issue of chief information commissioners be brought as a highlighting point? It is because that, when you say RTI is a fundamental right, it's a right that is protected by the Constitution, by the statute. You definitely, kind of give it some kind of a constitutional importance. I would not say constitutional status, because that is a status that is reserved for the Supreme Court, High Court, the President, the Prime Minister, so on and so forth. But it has constitutional importance. Now, you don't expect the Supreme Court to be headless. You don't expect the High Court to be headless. You don't expect important bodies not to have a chief, because the chief has certain important functions. And one of the functions that the chief does is in terms of allocation of cases, management of cases, and which cases are important, which should have urgent hearing. So I think he is probably somebody who administers the commission apart from adjudicating of second appeals. That is what the chief normally does. But interestingly, the Central Information Commission seems to have sorted it out from what I know and what I've read. Right now, they do not have a chief, but they are managing. So the remaining information commissioners, right now, there are only 5 in number, which I don't think is adequate enough. But the 5 are actually managing the cases between and amongst themselves. That is normally the rule. If you don't have the chief, probably if you look at it, the senior most probably takes over the decision, and then probably they manage the cases. So that is one point that needs to be brought to the attention of the government, so that they appoint the chief as soon as possible, and they can actually probably go about equipping the Information Commission adequately. Second, you will also notice that the second appeals are pending, and this is probably because of not having enough information commissioners. So it is very obvious. Now, you will also notice that the timeline. Now, interestingly, please note the timeline to fix second appeal is not there in the RTI Act. Kindly note, there's no timeline fixed for deciding second appeal. So if you look at the time frame under the RTI Act, a PIO must give information within 30 days. That's the first time frame. If the application is put to the APIO, that is Assistant Public Information Officer, the information should be given within 35 days. If the information is pertaining towards a third party, then the information should be provided within 40 days. These are the time frames that are fixed. The first appeal, please note, so if from the order of the PIO you go to the first appeal has to decide the appeal within 30 days. The maximum is 45 days. So there is a time frame for the first appeal. However, what is interesting to note is that there is no time frame fixed in the law for the information commissions to decide, right? So while we say that the PIO can be penalized for not providing or deciding on an application within 30 days, the CIC or the information commissioners cannot be penalized if they don't decide an appeal within a given time frame, because there is no time frame at all. Okay, so you'll have to note that as a critical point as we understand the right to information law, right? But again, let us not take away the fact that the CIC on an average is taking about 388 days, and you can't find fault with the CIC unless the CIC is adequately staffed, is adequately given the infrastructure. But I think the pendency is a matter of concern, because we always have said that justice delayed is justice denied. And RTI is also one form of justice delivery, right? The last point that I would want to emphasize on this slide is this 2.2% of penalties that are imposed in cases. Now, a lot of people think that penalties are not adequately imposed by the information commissioners. But to be fair and neutral on this point, I believe that 2.2% itself is quite a big number, right? Penalties are not supposed to be imposed in each and every cases. And you will notice if you read section 20 of the Right to Information Act, kindly note section 20 very, very carefully. Penalties cannot be randomly imposed for each and every cases. There are grounds on which penalties can be imposed. And it is the duty of the commission or the commissioner, when he writes an order of the penalty, to invoke the ground and then impose the same. So I think if one looks at a careful reading of the law, this penalty is in exceptional cases when the evidence and the facts suggest a deliberate, malified, knowing misconduct of the PIO in implementing the right to information law. Okay, so 2.2% is, according to me, quite amazing. If you compare RTI to some other legislations where you talk about accountability of government servants, this is an amazing phenomena, and I am for it. The last point is on the dilution part. To be honest, the dilution is not dilution. It's only bringing uniformity and certainty among quasi-judicial authorities in India. The RTI and the commissions that are established under the Right to Information Act are another quasi-judicial entity. And there are many quasi-judicial entities in this country. You have a lot of tribunals, right from taxation to consumer to so on and so forth. So the government probably realized that there has to be uniformity of salary, tenure, and structure. And that is the reason that amendment was brought in. And please note that amendment has been brought with the purpose of saying that this is how the Information Commission would now function as we go forward, right? So that's some kind of summary of what Vikas had to present in slide number 3. Vikas, what do you?
Yes, sir. Thank you, sir. Now moving to the what lies ahead. First of all is that there need to be ensured timely appointments of chief and members of the ICs. As we have just discussed, it is one of the most important posts are lying vacant that renders the information commission itself defunctional. And second point is that the hearing and disposal of the matters before the information commission must be fixed within a one timeline, because if the information commission takes years and years to dispose of one application, then after that year the value of the information can also drop, and it might not be have that impact or value to the applicant that it had over that time. And the third point that I would like to make, that RTI Act has now been extended to Jammu and Kashmir. During the discussion forum, we have this discussion on whether the RTI Act has been extended to Jammu and Kashmir or not. And thanks to the research work done by a participant of the course, we can now completely agree that the RTI Act has been extended to Jammu and Kashmir. Section 4, where we say that the suo motu disclosure, going ahead, the suo motu disclosure by the authority is going to be the key to reduce the number of RTI that are being filed. And now we have this vision of digital India. Then enacting an online RTI mechanism through where the RTI application can be filed on the net, that will help in the much better implementation of the act, sir. Thank you, sir, for the time, and I will hand the
Sir, if I
presentation as
may,
well. Yes, ma'am.
Yes, if I may just add on the last point,
Yes,
we
ma'am.
already have some departments which accept applications, RTI applications online, but it
Yes,
may
ma'am.
not have percolated to each and every department, at least in the state government. So I think it would be great to strengthen this act further and its implementation if more and more departments ensure and implement that their online RTI application regime works seamlessly. That will also help the applicants who are seeking information to not have to file, go to the post office, file all of this. So it will make the process a little more seamless. But there is already an online system available in the country, but it may not have reached all the departments. So just to add.
Thank you, ma'am. Sir? Hello?
Over to Raghav.
Yes.
Yes, sir. Thank you, Vikas, for that presentation. It was very informative and it was very insightful to have a glance at what has happened in the past 15 years. And we never really thought that we will have such a informative thing about looking back about the functioning of RTI for the past 15 years. It was for that. We'll move ahead with the queries that have been raised, and I'll start with the queries that have already been raised. And the first query is raised by Dr. S.K. Chaturvedi, and he's a faculty. The query that he has raised is whether private institutions who are affiliated with the government university are bound to provide any information under the Right to Information Act. If yes or no, please provide the answer with explanation.
Yeah, Mr. Chaturvedi, I don't think you have seen the video then. आप वीडियो देखते चतुर्वेदी साहब तो आप ये प्रश्न हमको पूछते ही नहीं, क्योंकि हमने उसमें पब्लिक अथॉरिटीज को इतना डिटेल में डील किया है कि आपको कोई कहीं और जगह इसका इतना विस्तार से विवरण नहीं होगा. आई एम नॉट पैटिंग माय ओन बैक, बट आई एम जस्ट टेलिंग यू दैट वेरी क्लियरली, right? So please go back to the video, please see it. And this is not like, I don't want to answer, but okay, so short and sweet. Private institutions are not directly, underline the word directly, covered under the Right to Information Act. Indirectly, yes, they are. How? You have to ask the controlling university if it is a public one, the affiliating university if it's a public one. You have to ask that public authority, which is the public institution, if they have the information in regarding to those private institutions, which they are the controlling institutions. And please note, whatever information they have, they'll provide it. They are not going to go and seek and ask information from these private institutions just because you have filed that RT application. So in India, please note, unlike some other country where there may be a RTI law, this act only brings accountability of public authorities, right? And the definition of public authority, if you have seen the video, is far wider than the definition of state under Article 12 of the Constitution of India.
Yes, sir. So he also has another query, whether
One per one person, that's enough. He'll go to the next.
All right, sir. The second query is raised by Mr. Sunil Kumar, and the query that he has raised is, will the question pattern in final exam be objective? Okay. This is pertaining to the syllabus.
No, Lian will answer that.
We can
Yeah.
answer that question.
Yeah, the question. I'll just.
Let them.
No, luckily, that person did not ask important questions. No?
If not, can we get the sample question paper? So that's.
Okay.
Lian.
I assure you that the question paper will be objective. So you can completely rely on the videos and the reading material provided. So in that case, there wouldn't be any need for a sample question paper.
Thank you, Lian. We'll go to the third question, and the third question is raised by Mr. Suresh Kumar. Mr. Suresh Kumar, the question he has raised is, in case of physical attack on RTI activist or filing RTI applications, complaint before the respective state information commission under section 18 of the RTI Act.
Yeah, but what will you get from the Information Commission if you have threat? Do you think the Information Commission is going to be a police and give you protection? No, I think there are more efficacious remedy available under general law or general criminal law, right? So if you have received some threat, I request you, please go to the local police station with the evidence of the same and file an FIR. And you should go to the local commissioner and seek protection of police. So I don't think the Information Commission is going to, interpret any other law. So let me be very clear about it. The Information Commission has been established under the Right to Information Act. They can exercise their powers and functions only vis-a-vis the RTI Act itself, not any other legislation, right? Normal courts can apply any law, but quasi-judicial bodies can apply only their law. And that's very clear. Supreme Court has said this, clarified this time and again, right? You derive powers from RTI. Your functions are vis-a-vis only this act, and you cannot use general powers. So my request to you is go to the police commissioner, seek police protection, file a complaint, lodge an FIR, and see that you are protected.
Okay, the next question is raised by Mr. Sanket Chakraborty, and that he is.
Raghav, we can do some legal advisory work to the person. You can tell him he can come to us for
But I think so. The query that he has raised is a little.
You can give your email ID, Raghav, and you can say that we are practitioners, practicing advocates, and we take up cases. Yeah, let the participants know if they have any other assistance, legal assistance, consultancy, or advisory that they wish. They can get in touch with us. Sure, no problem. Put across the email ID if you don't mind, Raghav. Yeah,
definitely. I'll do that. So I'll mention the query here. The query that he has raised is if an RTI applicant does not get any reply or gets irrelevant replies from the SPIO, appellate authority, and even after the second appeal, he does not get an opportunity of hearing, he should definitely approach the court of law, and to be more precise, the High Court. Now, should he or she make the registrar or the CIC, as the case may be, the respondent of that particular litigation, along with the concerned SPIO and appellate authority?
that depends. That depends upon who is at fault and against whom the case is being filed. See, to be honest, if you don't get information, it is the fault of the public authority or the PIO in particular. But generally, unfortunately, what has happened is you are preferring not an ordinary appeal. When you go to the High Court, Raghav, I think you know more than I do, that it is invoking the writ jurisdiction. And when you invoke the writ jurisdiction against a quasi-judicial body like the Information Commission, you make the commission a party because you are challenging that order.
Correct.
But it's not commission in its personal capacity that is going to defend the case. It's just against the order of the commission, you are filing the writ petition. That's it. So the commission is not having personal stake in defending its own judgment before the High Court or the Supreme Court.
Correct.
Because judges when they give, and let me tell you, when judges or information commissioners, when they give judgments, they are not doing that in a personal capacity. They're doing it in an official capacity. That's the end of it, right?
Correct.
However, because it is the CIC order, it will be Sairam Bhat in the High Court versus the CIC. That's all. Because
So the next query is raised by Ms. Shweta Katoch. And the query she is asking is, what can be the possible ways to ensure effective implementation of RTI? This is a pretty vague question and more broad in nature.
Madhu. Or anybody else, yeah, please.
So if I may just ask, I think the participants can go back to the last slide that Vikas had presented. That in a way sums up the points that we need to ensure better implementation of the RTI Act. Also, if no frivolous questions are asked, I mean, the Act very specifically lays down what kind of information can actually be accessed by the public. So if you don't want your applications to be rejected or to be returned with no answers, ensure that you ask the right questions. That is also very important. And other things are points which the government has to look into by ensuring that enough officers are appointed to address the queries that people may have, and to again better the implementation of the act. If suo motu disclosures are made, that is also another way of ensuring that the different commissions and the PIOs are not flooded by RTI applications, because if and usually the questions that pertain are not how, what, why. It's basically just information that you have that can be given. So please ensure that you know the right questions to ask. So these could be some of the ways in which the implementation can be strengthened. But this is something that will happen over time and not overnight. So we will have to patiently wait for that.
So another important point that I would like to mention here is that I think there is a lack of awareness also among the common citizens to about the applicability or the implementation of their rights itself. So most of them don't know. I mean, we as professionals, we understand the lacunas in the law, but some of the people who can exercise their right, but they are not aware that there is some right like this which is existing, which can be excised. So I think for the effective implementation from the government side, I think as what Madhu ma'am mentioned, that is appropriate. But from the perspective of the citizens, the awareness has to be increased, and right to information as a right has to be better informed to the citizens so that it can be implemented in a better manner. Move to the next query. Sir, another query is what are personal information which are exempted under the RTI Act? Please discuss with some examples.
Why should I discuss in this live session? Which week is that? Vikas or somebody will tell you. I think have patience, friends. We have discussed section 8.1J. Preetham also has raised this question.
Yes.
Probably most of you are quite curious. Maybe somebody has asked this under RTI. आपका पर्सनल इन्फॉर्मेशन कोई मांगा है क्या? इसलिए आप मेरे से पूछ रहे हो, दे सकता हूँ या नहीं दे सकता हूँ, या मेरे को ऐसा लग रहा है कि आप में से कोई किसी का पर्सनल इन्फॉर्मेशन पूछना चाहते हो. ऐसा थोड़ी है. तो पता नहीं, you guys are so curious about knowing others' personal information and you want to know the interpretation of it. But I think the broader issue is very important. It is important from the fact that today, unlike when the RTI Act was enacted, right to privacy has become a fundamental right. In the Justice Pottaswamy case, the Supreme Court, with 9 judges, held that right to privacy is a fundamental right. Right? Now, how does that declaration under the Constitution of India, and please note we are awaiting a privacy and a data protection bill to be passed by the Parliament. It will soon come. Let me assure you that it should come within probably the next 6 months. We should get a new law. Now, that law will be a direction probably for the CIC or the SIC to implement Section 8.1J. That's what I believe in, right? Because privacy would be defined. There would be some kind of a guide for me to decide what is privacy and what is not privacy. Right now, I think what is the guiding document, there is no document per se, but probably the guiding precedent are previous cases which have been decided by either the Supreme Court or the High Court or the CICs, the SICs. Right? Then I decide what is personal information and what is not personal information. But let me tell you, the biggest setback that RTI received, and I believe that it's a setback for the reason I can substantiate on a very long lecture, is the Girish Ramchandra Deshpande case of 2013 of the Supreme Court of India. Now, till that point of time, till 2013, a lot of public servants were accountable under the Right to Information Act in respect of their public function, their public duty, and public service. Unfortunately, the Supreme Court reversed that trend in 2013 in the Girish Ramchandra Deshpande case. which clearly meant that my services in my public authority are my personal information, right? Now that also extended to my physical health or even mental health for that matter. It also probably extends to my family details because it is there in the service book or the service register, right? So very clearly you would notice that employee related information thereby then becomes personal, right? You cannot seek that under the Right to Information Act. You have no business to do that. So I think personal or non-personal information is very, very important to know the set of limitations on seeking what you can get under the Right to Information Act, right? Now, this is in terms of my individual. So I may be a public servant, but I have my personal life, I have my personal time. And as a public servant, some information can be given, but regarding my personal information, you should not seek. However, what is important is also to distinguish between an individual and an entity in which you talk about confidential information, right? Confidentiality is something that is very critical. And let me tell you, public sector companies, public authorities have confidential information and they are not supposed to give that under the Right to Information Act, right? That's how we make the segregation of confidential information and probably personal information. Right? So, it's like saying you must all be saying that the prime minister and the president are public servants, so I can ask anything about them. No, I don't think that is something that the RTI encourages at all. I think public servants have privacy, and that privacy has to be protected. It's a fundamental right of all citizens, be it public or private, right? And you will also notice that the kind of violations of privacy that is happening, especially with journalism right now. And you know that the Chief Justice of India, Justice Bobde, has asked a news channel to explain, how they would actually, report from now on, because sometimes journalists also tend to invade privacy. So I think it's a big contest that is going on, and I think we need to define privacy, especially today in the digital world, in the online world. For example, this is on YouTube, and I would say that in the YouTube, my privacy is going to be violated. How do you think? I'm giving a lecture only to a limited audience. Why should everybody view it? So I can restrict my own space, and I would probably not want anybody else to deal with it. Right? So I think that's something that RTI has to mature enough, and I'm sure it will do so once the Privacy and Data Protection Bill is brought as law.
Yes, sir. The next query is raised by Mr. Vinay Bembalkar, and he has a query that is pertaining to the banks, whether private banks come under the RTI Act.
Same. Good. Next question.
Next one is a pretty lengthy one. Yeah. Query is, if PIO is collecting and providing information as per the format specified by applicant, what will be then deemed that information is created? Please note, in this case, the information is not. So this is pertaining to a case that has been asked. So it's the case is Vibhor Dilip Barla versus Central Excise and Customs. It's a 2006 case. So they're asking about the format to be specified in the application.
You cannot ask information in a specified format. It will be given to you in the format in which the government keeps it. That's very clear. You cannot ask for a change of format. You cannot ask saying that, look, I want it in a pie chart, in a flow diagram. It is easy for me to understand. नहीं, वैसा नहीं हो सकता है. आपको information जैसा है वैसा मिलेगा. उसको लेने के बाद आप उसको पाई डालो, केक में डालो, कुछ भी कर लो, statistics बना लो, वो आपका निजी काम है. But government rules and regulation में information या records को कैसे रखते हैं, वैसे ही रखेंगे, वैसे ही आपको देंगे. वो clear है.
Yes, sir. So the next question is raised by Mr. Vikas Yadav, and the question is how RTI is different from query, inquiry, and grievance.
RTI is neither a query nor an inquiry, nor is it a tool to redress your grievance. Very simple. It's only a law that gives you information. From that information, if you have any grievance, if it is pertaining to what has been given and when it was given, then you can go in appeal, right? But if you have grievance saying that आपको ये facility government ने नहीं दिया, वो नहीं दिया, इसके लिए RTI is not the mother of all your solutions. It's not something that will redress all your grievances. There are other laws, there are other agencies that are responsible. For example, if you have a grievance from a consumer product, why should RTI address it? If you have grievance from the electricity department, why should RTI? So you can ask information. Please note, that is all the RTI Act is all about. But to be honest, by taking such information or filing RTI, a lot of people have experienced that their grievance has automatically been addressed. This has happened because there is a change of attitude of the government servants. So that success stories we have heard for the last 15 years. So आप अपना लक ट्राई कीजिए और होपफुली आपका ग्रीवियंस जो है या इंक्वायरी जो है वो इंटरेस्टिंग बन जाए, हो सकता है.
Yes, sir. So Mr. Arnab Roy asks this question. Any RTI query is raised to municipal authority, and if they don't give the answer within the specified time limit, who will be the higher authority for filing first appeal and second appeal? Is
Municipal
it the
commissioner.
administration?
Yes, it depends upon which city he is talking from which state he's coming, but it's the municipal commissioner. Yeah. DC, depends. Yeah.
Yes, sir.
Usually it is, who is heading that public authority is generally the one who is the first appellate authority. It's all provided on the website. You should just probably find out who that first appeal is. And let me tell you, the PIO, the public information officer, when he is replying to you or when he's passing an order or providing that information, he is duty bound to also tell you who the first appeal is. He has to write in that covering letter. He will communicate that to you. Correct. So you will be informed who is the first appellate authority.
Yes, sir. So the next query is with regard to the disciplinary proceedings. So if the disciplinary proceedings recommended under Section 20 Clause 2 is not obeyed, can the CIC or the SIC take action against such public authority?
No, they cannot. So to be honest, I have a counter question. The counter question is, political parties were supposed to be brought under RTI by the CIC order. Now they are not coming. So what has CIC done? See, remember, all this comes from or stems from the fact that we are thinking that there is contempt law or contempt powers with the Information Commission. They do not have power. But you can probably go to the court and say, look, there is already an order from the Information Commission, and that order has not been complied with, and hold the public authority accountable in a writ jurisdiction. That's possible. But again, you have to show why you are going to the court. What is your locus? It could be in public interest, probably. You never know.
Yes, sir. So the next question is again a little vague. The question is Aadhaar card a proof of citizenship? I think this is not relevant for the purpose of discussions.
Aadhaar is proof of nothing. Okay, Aadhaar is just a unique identification number. It is used for government identification, for government recognition, right? It neither proves one or neither disproves the other. So the Aadhaar debate is a very long debate, right? It has resulted in a very long Supreme Court case as well. How did Aadhaar come in? Was there an act to collect information, privacy, so on and so forth, right? And Aadhaar as a means of ensuring entitlements, especially the schemes or benefits that the government gives. So many issues were in the Aadhaar case, and they were all discussed in the Supreme Court. So right now, Aadhaar is only your unique identity. That's it. Full stop. Sweet and
so one more point to add on to that is, it also acts as a proof of residentship. Even though it does not confer citizenship, it is a proof of residentship. So because everywhere the Aadhaar is such convenient method it has provided that everywhere you go, you have to update your residency, the residency situation or position in the Aadhaar card. So that is...
You are inevitably, you have to link Aadhaar to your PAN,
Yes.
Those are conditions that the government has already brought into place. So you have to comply with those conditions because it's a unique identification and it helps government to remove benamis, to remove fake entitlements, fake benefit claimers, so on and so forth. So that is probably a public policy intervention of the government.
So, Mr. Balaji Rajendran, these are the questions from YouTube, sir. I think we have 2 or 3 questions from the YouTube. The first question is with regard to the public interest. Mr. Balaji Rajendran is asking what exactly is the term public interest?
Balaji, public interest is, in the words of the Supreme Court, an unruly horse which nobody can define or control. So there's nothing like a perfect definition that we can even look at. Public interest keeps changing from time to time. It's dynamic. Public policy, public interest is what the government could define. And let me tell you, public policy and public interest is what even the court defines from time to time. Right? It can be subjective. You can probably have a very broad parameter of what its objectivity is. For example, in arbitration, public interest would mean the fundamental law of India, the sovereignty of India, the integrity of this country, so on and so forth. So there's nothing like, an acceptable definition. Now in RTI, if you are asking this question, this very clearly depicts the fact that exempted informations can also be provided in case of public interest, right? Now, exempted information is not final. It's not something that is never going to be given. It may be shared at times, provided there is a larger public interest. That is the word that is being used under Section 8 of the Right to Information Act. Larger public interest. It's not simple public interest, larger public interest. Right? Now, that is something that the Information Commission has to apply as a rule. He has to see whether, even though it is exempted, even though it is not to be provided, in giving it, would it serve the larger public interest? Right? Now, what is a larger public interest, especially when exempted information has to be provided? I would say corruption. I would say nepotism. I would say any of the issues in which probably the larger public interest would be adversely affected. And hence, there is a need to give this information in the public domain. The second test that I can also suggest in trying to determine the larger public interest is violation of human rights. And that's why we say even exempted organizations, I hope you know that under the Right to Information Act, there are certain organizations that are exempted. Even exempted organizations are not exempted on 2 grounds, human rights and corruption. Right? They have to provide it. So I think you can try and look at what is larger public interest, but I think it has to be applied, it has to be justified, and it has to be proved. And the Information Commissioner has to be satisfied that yes, such an exempted information can be provided. Right? That's a sum and substance of what I can say of larger public interest.
Yes, sir. So one more question is pertaining to Mr. Preetham. I think he has asked about 81J. I think we have already.
I have answered it. I think there is Abhishek who is asking about the PM CARES Fund. Yeah. Now, we have settled this matter in the first session itself, Abhishek. Okay. So the matter is settled. Now the court has held, and let us accept the court's judgment as the law of the land as per the Constitution of India. Right? The court has very clearly declared that the PM's CARE Fund is not a public authority under the Right to Information Act. I think the debate must come to a full stop unless somebody is filing a revision petition asking for a review. Right? This debate cannot go on for long. That law as it stands today has to be accepted and we have to move forward. Right? If somebody wants to challenge it, yes, review petitions can be challenged and then we can come up to the new position of law. That can always happen. So I'm not denying that fact. But as of now, as it stands, it is the court, constitutional courts that have said it's not a public authority.
Yes. So the last question is pertaining to a case that is Vijay Trayambak Gokhale. It is raised by Swinder Singh.
We don't have to address that case right now.
All right, sure. So these are the queries that are raised both from. Yes, sir.
Anybody else wants to chip in, please come.
Lian?
Yes, am I audible? I would just like to point, I mean, after having such a insightful discussion based on the presentation given by Vikas as well as on the questions that have been raised, um, I would just like to say that when we look at the RTI Act, especially at its design, there is a balance in which the Act strives to strike between, as Sir pointed out, the right to privacy as well as the right of the public to generally gain information at large. So as we progress through the sessions, you will understand in terms of the powers of the authorities provided under the Act as well as the rights of the public to receive information, how this balance has been struck. Now, I understand there are few queries regarding the powers specifically of the public information officer and the state public information officer. I think those will be covered in the coming sessions. So we will probably have to hold on to your seats and wait for them to be addressed. But one last point that I would like to point out, just to wrap up this discussion, is that if you are looking at making the RTI Act more effective in terms of implementation, it's very easy to pinpoint the lacuna or the flaws on part of the authorities mentioned or the working of the authorities provided under the Act. But at the same time, we must realize that there are the first step begins with the general public being aware of basic requirements of how to file an RTI, how an RTI has to be worded, what are the minimum fees in terms of the application fee or the information fee. I think the first step begins with being aware of what the law is. And in order to be aware of that, I think the first step would be to read the law as it is. So as we progress, I think having just a brief overview of what this Act talks about and what are the provisions of the Act would give much more clarity on how do we exercise this right to information.
So I think we'll conclude the session, today's session, about how the functioning of RTI has been for the past 15 years. And before I conclude the session, I'll just introduce my team members. As we all know, team is headed by Professor Dr. Sairam Bhat, who is the coordinator of the center. And we have with us Ms. Madhubanti, who is also the center in charge. And Mr. Rohit Kamath, in his absence, he's, I think, just watching the video, but not able to take part in the discussion. And myself, Raghav, and next we have Ms. Geetanjali, Mr. Vikas, who did a wonderful presentation, and lastly, Lian. So I thank you all for joining the discussion and raising some crucial questions about how the RTI has been functioning. And I hope we are able to keep your interest up through the videos, and we'll look forward to join you in the next session, next discussion. I'll request you to please keep up your interest and raise some pertinent questions. Also, please keep yourself updated with the recent happenings with regard to the RTI and other related aspects. Thank you all.
I can just add, we'll also have one more live session in the month of November. I'm sure Vikas is planning another live session. That would be the final one. And also the fact that in case you guys are interested in taking one of our publications, we have a book on RTI. You can write to us. The price of the book is 500 rupees. Right. So if you write to us, we can send the book to you. So it's available online if you want to just check. It is RTI and Good Governance. That's the title of the book. And yes, all the very best. Good evening. Thank you, team, for joining me today.
Thank you, sir.
For Karthik to